Good vach. It's great to be learning with you on a Saturday night. Let's light up the darkness. Who's in the house as we start off the week with some beautiful Talmud learning? Joe in the Inland Empire, Bill in mid-Missouri, Shandora in the Bronx, Sharon in New Jersey, Stephen in New Hampshire, Nancy in North Carolina, Chaim in Florida, Ella in South Carolina, Southern California, Allen in New York City. Welcome, everybody. Our daf tonight is page 128 here in Tractate Bava Basra, the 23rd volume of the Talmud, continuing our journey through chapter 8 and our discussion of Mishnah number 5. Picking this up right at the bottom of page 127b. Rabbi Abba sent several rulings from Eretz Yisrael to Rav Yosef Bar Chama, including the following. So here's going to be a series of rulings that were sent from Rabbi Abba to Rav Yosef Bar Chama. Some of them are about inheritance, as we've been discussing, whether a father can bequeath his assets, his estate, contrary to what it says in the Torah, that the oldest son gets the double portion, his oldest son, his firstborn son, and the other sons, get equal parts. Or, we've already seen, according to the opinion of Yochanan ben Baroka, that the father can dispose of his estate the way he wants. But what he can't do is write in the will something that is explicitly contrary to the law of the Torah. So if he says, I'm gonna hereby leave my inheritance to my sons, and my firstborn will not get a double portion, then we just set that aside. But if he says, I'm giving a gift of all my assets to my third son, that he's allowed to do, because during his lifetime he can dispose of his assets however he wants. Even if he says, I believe, I'm giving it as a gift to my third son, and he can receive it after I die. Now, that's the same idea as an inheritance, but it's not, because he made the gift now. So he can't make a will that expressly violates the Torah, but he can dispose of his assets using the language of gift rather than the language of inheritance, however he wants. Even if he writes that in the will, he simply has to use that language of gift. Now, obviously, there's a lot more to it than that. And if you're, creating a will, you should talk to an estate lawyer and the rabbi, if relevant. But that's what the Mishnah was talking about. And now we're getting related rulings, including where we were talking yesterday. Is a father deemed credible to identify who his firstborn son is if there was a presumption perhaps by the village, by the town, by a court especially, that one of his other sons was the firstborn? Okay, so now we have related questions. So Rabbi Abba sent several rulings from Eretz Yisrael, right? So from the rabbinic community in Eretz Yisrael, which was laboring under the oppression of Rome, to the rabbinic community, which had a lot more freedom to learn and teach Torah in Bava, right? Babylonia, which at this time was part of the Persian Empire. So Rabbi Abba sent several rulings from Eretz Yisrael to Rav Yosef Bar Chama, including the following. In the case of one who says to another, "You stole my slave," and he says in response, "I did not steal him." And when the first inquires, "If so, what is the nature of his presence," right, my slave's presence, "in your possession?" And the latter responds, "Well, you sold him to me." Now we're on 128a. Or he responds, "You gave him to me. You gave me the slave as a gift." So if he then adds, and of course it's difficult for the modern ear to talk about slavery. This has not been legal in thousands of years, thank God. But we're discussing the law as it was. So you gave him to me as a gift. So if he then adds, "Although I owe you nothing, as the slave is mine, if it is your desire, take an oath that he is yours and take him." And the claimant takes an oath that the slave is his, then the one in possession of the slave cannot retract his offer, although he was not obligated to make the offer. Now, this has nothing to do with the law of inheritance, but yesterday we were talking about that if somebody has a son that everyone assumes is his son, and then he says, "Well, actually, he's not my son, he's my slave," do we believe the father when he, relabels his son to actually be a slave, or vice versa? We thought it was the man's slave, and he says, "No, actually, this is my firstborn." Does he then inherit the double portion along the other sons? And because we were talking about that, now we're on this digression. Now the Gemara asks, what is Rabbi Abba teaching us? We already learned in a Mishnah, Tractate Sanhedrin 24a, that if one of the litigants said to the other, "My father is trusted to adjudicate for me," or "Your father is trusted to adjudicate for me," or "These three cattle herders, who are not experts in halacha at all, are trusted to adjudicate for me," and all of the individuals this litigant mentioned are legally disqualified from serving as judges, either because they just don't know the law at all, or because they're related, right? You can't go to court and your dad is the judge. There would be a disqualification for your dad as a judge. Rabbi Meir says that the one who stated this can retract his statement, but the rabbis who overrule Rabbi Meir say that this person cannot retract it, and he is obligated to have them serve as judges if the other litigant so desires. Meaning, you would not go to court against another party whose father is serving as the judge. But if you say, it's okay, your father can serve for me as a judge, so then the rabbis say, okay, well then you waived your right to disqualify that judge, so now you're going to have to accept the judge's ruling because you waived your right. You could have protested and said, this is totally unfair, I'm not going to go to court against somebody whose father is the judge, but if you waive that right, okay, so it's waived. Rabbi Meir says you can't waive that right. Now, the Gemara in Tractate Sanhedrin records a dispute between Amoraim as to the circumstances of the case of that Mishnah, with one Amora, that's a rabbi of the Talmudic period, holding that the dispute pertains only to a case where the one accepting the disqualified judge will need to forgive a debt if the judge rules in accordance with his opponent, while a different rabbi holds that the dispute pertains even to a case where this one who waived his right to disqualify a judge, if he loses the case, will not only have a debt forgiven, right? He's not going to be able to collect money from the other party, but even the stronger case, that he's going to have to pay money to the other party. He owes that guy, and if the judge so rules, he's going to have to, send over money, pay money to the other litigant. By stating his ruling in a case where the litigant will have to give the slave to the other, which is how we got here, Rabbi Abba teaches us this, that the dispute between Rabbi Meir and the rabbis is even in a case where the litigant said, I will give you what you claim, as opposed to I will forgive what you owe me. Here, I will give what you claim from me. That this is even in a case where the litigant says, I will give you what you claim, if that is the ruling of these judges. And the rabbis hold that if he subsequently wishes to retract his suggestion, right, he said, when he realizes he shouldn't have waived his right, then it's too late, right? He waived it, so he can't un-waive it. And Rabbi Abba also teaches that the law is in accordance with the statement of the rabbis, right? That if you have a right to protest, but you don't, so you waive your right to disqualify that judge, so it's waived. You can't later say, oh, I was wrong, I shouldn't have waived that right. You waived it. New ruling from Rabbi Abba to Rav Yosef Bar Chama on a different subject. Rabbi Abba also sent a ruling to Rav Yosef Bar Chama that the law is that the creditors of one who died collect the debts from the Canaanite slaves that the deceased left to his heirs. So Canaanite slaves as opposed to Hebrew slaves. Canaanite slaves were slaves forever unless the owner freed them. Hebrew slaves only served for 6 years. So in other words, Canaanite slaves could be inherited, right? A father could leave the Canaanite slaves as property to his son. So the law is that the creditors of one who died collect the debts from the Canaanite slaves of the deceased left to his heirs. In other words, somebody owes money to his creditor and he dies and he didn't pay the debt back. So the creditor can show up and say to the heirs of the guy who died, your father owed us money. You have to pay from his estate. And if this estate only contains a Canaanite slave, well, then the creditor is going to take that slave. If the slave is worth more than the debt, presumably they would sell the slave and he takes the money that he's owed and the rest of the money goes to the heirs. And therefore, this shows that slaves have the same status as land, legal status as land with regard to a debt that has to be paid by the estate of the deceased. And Rav Nachman says that the creditors do not collect that debt by taking the slaves. And the reason for that is going to be that slaves, according to this view, are not compared to land, but rather are compared to movable property, which a creditor cannot seize from the heirs of someone who died. Next ruling, Rabbi Abba also sent a ruling to Rav Yosef Bar Chama that with regard to people with a common ancestor, the halacha, the law, is that the testimony of members of the third generation with regard to members of the second generation whose closest familial connection is through that ancestor is valid. That's pretty complicated, so there's an example. For example, one can testify about his first cousin once removed and is not disqualified as a relative. Right? So you can't appear as a witness in a case involving your first cousin, but you can appear as a witness in a case involving the son or daughter of your first cousin. Rava says even the testimony of members of the third generation with regard to members of the first generation is valid. For example, one can testify about his great uncle. And Mar Bar Rav Ashi deemed one's testimony with regard to his father's father valid, as he considered it a case of testimony of a member of the third generation with regard to a member of the first generation. In other words, since we can say that that a relative is not permitted to testify in a legal case involving a relative, that's only for close relatives. And since we're going from one generation to the third generation, therefore grandfather could testify for or against his grandson, and vice versa, according to the view of Mar Bar Rav Ashi. But the halacha is not in accordance with the opinion of Mar Bar Rav Ashi, so a grandfather cannot testify for the benefit of his grandson and vice versa. Another ruling. Rabbi Abba also sent a ruling to Rav Yosef Bar Chama concerning testimony. If one knew information that could serve as testimony about the boundary of another's land, and he knew that before he became blind, And then this person became blind. So he is disqualified from bearing witness in a dispute as to the boundaries of that person's properties, right? So you have there's a legal case involving what is the boundary line between two fields. And the one, who was present when these fields were originally, let's say, broken up, let's say that they were part of a massive ranch, and at a certain point, the owner of that ranch broke up the fields and sold them individually. And then the boundary marker was moved in an earthquake or was stolen by robbers or, whatever. And now there's a dispute going on that's come to court about where is that boundary line between those two fields. And the litigants, the guy says, it was here. The other guy says it was there. And how are they going to prove where the original boundary line was? But they find this old timer who was there when the original division of that ranch into separate fields was made. And he saw it made. And he says, yes, and there was a tree, and we paced it off, and it was 10 paces from the tree, and that tree is still there. And so there's the truth. That's the answer. That's who you want to testify in court. But the problem is that since then, that old man became blind. And a blind person is disqualified from testifying in court. Now, obviously, there's many blind people who are completely qualified to testify about any number of subjects. But here we're talking about traditional law, and a blind person is not permitted to testify in a case, according to that law. Even though at the time that he saw the relevant information, he was not blind. That's what they're talking about here. And that's Rabbi Abba's view in the name that sent, in this ruling that he sent to Rav Yosef Bar Chama. And Shmuel said he is fit to bear witness. The guy who's now blind is fit to bear witness, as it is possible for him to determine the boundaries of the fields despite his current blindness. But he is not fit to identify a movable item, for example, a cloak, as he cannot see it. And Rav Sheshes said he can identify even a cloak, as it is possible for him to determine its length and its width, but he is not fit to identify a piece of silver. And Rav Papa said he can identify even a piece of silver, as it is possible for him to determine its weight. Now the Gemara raises an objection from a Baraisa. If one knew information that could serve as testimony about another before he became his son-in-law, and then he became his son-in-law, thereby becoming a relative who is disqualified from bearing witness concerning him, or if he was able to hear at the time that he witnessed an incident, and then later he became deaf, or he was able to see at the time that he witnessed an incident, and then became blind, or if he was halakhically competent and then he became insane. In all these cases, he is disqualified from bearing witness, like the original ruling of Rabbi Abba. And that Baraisa continues, but if he knew information about him that could serve as testimony before he became his son-in-law, and then he became his son-in-law, right? So when you're a son-in-law, you can't testify against your father-in-law. The relation is too close. Therefore, you're disqualified as a witness, even though you could provide information that would be useful to your father-in-law in that case, but you're disqualified as a witness. So even though at the time that you witnessed the incident, you weren't married to the man's daughter, so he wasn't your father-in-law, nevertheless, between the time of the incident and the time of the trial, you married that man's daughter, so now you're disqualified from serving as that man's witness, your father-in-law. But then the daughter dies, so that this man is no longer related to his father-in-law. You see? You saw the incident, so you could testify about it. Then you married the guy's daughter, so now he's your father-in-law. Now you can't testify about it. Then sadly your wife dies, and now he's no longer your father-in-law. Now you can testify, since you were fit to be a witness at the time of the incident, and you're fit to be a witness at the time of the trial. So even though you had a period where you were not qualified to serve as a witness while you were married to his daughter, in between the incident and the trial, you nevertheless can testify at the trial. Or if he was able to hear, right? He was somebody who could hear, and then he became deaf, and then again he became able to hear. Or if he was able to see, and then he became blind, and then again he was able to see. Or if he was halakhically competent, and then he became insane, And then he was cured and became halakhically competent again. In all these cases, he is fit to bear witness. And this is the principle. Anyone whose initial state or his ultimate state, i.e. his state at the time of the incident or his state at the time of the testimony in court, is one of disqualification for bearing witness, he's disqualified. But anyone whose initial state and his ultimate state is one of fitness to bear witness, he is fit to bear witness, even if he was disqualified in the interim. And this Baraisa clearly states that one who is blind is disqualified from bearing witness if he's blind at the time of the testimony. And the Gemara concludes, the refutation of the opinions of all the Amoraim who held that a person who became blind after witnessing a matter can in certain cases testify about it is indeed a conclusive refutation. Wait a minute. So in other words, they cannot testify, just to make sure I understand that. Let's just read the law. One cannot testify about what he witnessed when he was deaf, blind, or insane, even if at the time of his testimony he is able to hear and see and is halakhically competent. And similarly, if he was fit to testify at the time that he witnessed the incident, but by the time of the testimony he became disqualified, he cannot provide testimony in accordance with the ruling of that Rabbi Abba sent to Rabbi Yosef Bar Chama. If he was fit to testify both at the time he witnessed the incident and at the time of his testimony, even if in the interim there was a period during which he was blind, deaf, or insane, his testimony is nevertheless valid. So it was a conclusive refutation of the ones who said that if he was fit to bear witness when he saw it, even if he was blind or deaf later, he would be fit to testify. Those sages have been refuted. Now, we're at the page 128b, and another ruling that Rabbi Abba sent to Rav Yosef Bar Chama. One who says something concerning one child among his sons is deemed credible, and Rabbi Yochanan says that he is not deemed credible. It's a very vague statement. What does it mean? And the Gemara asks, what is Rabbi Abba saying? Abaye said that this is what Rabbi Abba is saying. One who says concerning one child among his sons, right, about one of his sons, that he shall inherit all my property, is deemed credible, in accordance with the opinion of Rabbi Yochanan ben Baroka, who holds that one can bequeath all his property to one of his heirs. Okay, so you see what the problem is. This is stated as, okay, a person has the option, we're going to allow him to bequeath his property to one of his sons rather than dividing it among his sons with the firstborn getting a double portion. Is he permitted to do that? Is he not permitted to do that? Okay, that's a debate between Rabbi Yochanan ben Baroka and other sages. But the problem here is that this ruling that Rabbi Abba sent to Rav Yosef Bar Chama is in the language of he is deemed credible. What does credibility have to do with somebody making a choice to leave his property to one person, to one of his sons, or all of his sons? That's not an issue of credibility. That's an issue of whether he can do that or not. Not whether he's deemed credible, whether a person is credible or not. That's an adjective that we use to describe whether a witness is qualified or not, whether he's believable or not. Not if that is the desire of a father how to dispose of his assets. And Rabbi Yochanan says that he is not deemed credible in accordance with the opinion of the rabbis who disagree with Rabbi Yochanan ben Baroka. So again, this question of credibility, that doesn't sound like can he dispose of his assets in that way or not. Rava objects to this explanation. According to Abaye's explanation, this wording is deemed credible and not deemed credible. This is not precise. And he should have employed the terms that if that's what he wants to do, his son shall inherit or his son shall not inherit. As the issue is the ability of the father to specify who will inherit from him, not his credibility. So rather, Rava said that this is what Rabbi Abba was saying. One who says about one child among his sons that he is the firstborn, the father is deemed credible to make that statement, in accordance with the opinion of Rabbi Yehuda on page 127b, and Rabbi Yochanan says that he is not deemed credible, in accordance with the opinion of the rabbis who disagree with Rabbi Yehuda, which we discussed yesterday. Now we see why these rulings that Rabbi Abba sent to Rav Yosef Bar Chama are included in this discussion that continues from yesterday. But we have another ruling. Rabbi Abba sent another ruling to Rav Yosef Bar Chama in a case of one who says, my wife will take a portion of my estate like one of my sons. She takes a portion like one of the sons, as it is considered a gift. It's not that she's inheriting, it's that he's making a gift to his wife, and he can certainly do that. Rava says, and this ruling is only with regard to the husband's current property, which he can give her as a gift. But the husband cannot give her a portion of his future property because he doesn't have it yet. And furthermore, the calculation of her portion must take into account not only the number of sons the husband has at the time of his statement, but also the sons who come, i.e., who will be born afterward. So what they're saying is, my wife, I'm gifting to her a portion of my property alongside my sons. Okay, so when he made that statement and he was able to give that as a gift, so we would need an accounting of what property he owned at that time. And then even if sons are born later, so upon his death, his wife is going to get an equal portion of the assets that he owned at the time he made the statement. But any property that he acquired later after he made that statement, she won't get a portion alongside his sons because he can't bequeath to her, he can only gift to her. Rabbi Abba sent another ruling to Rav Yosef Bar Chama in the case of one who produces a promissory note against another. And the creditor says, I was not repaid anything. And the debtor says, I repaid half the debt. And the witnesses testify that the debtor repaid the entire debt. Then this debtor says, so this is very interesting, right? Somebody lent money, right? I lent money to you. And then I say, you haven't paid me back anything. And you say, Sal, what are you talking about? I paid you, you lent me $100 and I paid you back $50. And I say, no, you didn't pay me anything. You say, Sal, I paid you back $50. I say, well, let's bring in witnesses. The witnesses come in and say, actually, you paid Sal back all of the money. You're thinking, whoo, now I don't have to pay anything. But I said you paid nothing. You said you paid 50. The witnesses say you paid 100. Now what's going to happen? The witnesses testify that the debtor repaid the entire debt. Then, this debtor takes an oath that he repaid half, as is the law with regard to one who admits to part of a claim, and he is exempt from paying that half. And the creditor collects the second half from unsold property, but not from liened property that was sold after the loan, as the buyers can say, hey, we relied on the witnesses that the debt was repaid in its entirety. I am almost done. Questions or comments, please get them in now. Just making an adjustment here. Hold on. Okay. Now, the Gemara compares this law to the case of a promissory note that states that the debtor owes the creditor, quote, sella coins, plural, sella coins, but it doesn't say how many. So the creditor claims that he lent the debtor 5 sella coins, and the debtor claims that he borrowed only 3. Rabbi Akiva holds that since the wording of the promissory note indicates a minimum debt of 2 sella, because it's plural, and the creditor could not have collected the 3rd sella without the debtor's admission, right? The debtor admits that he borrowed 3. So the latter's admission to part of the claim cannot render him liable to take an oath. And the Gemara states, and even according to Rabbi Akiva, who says that the debtor is not liable to take an oath, as with regard to the 3rd sella coin, his legal status is similar to that of one who returns a lost item. This statement applies only in a case where there are no witnesses to the loan. But where there are witnesses, as is the case in Rabbi Abba's ruling, the debtor fears denying the entire debt. Therefore, he is liable to take an oath that he repaid half as one who admits to part of the claim. And finally, Mar Bar Rav Ashi objects to this. On the contrary, even according to Rabbi Shimon ben Elazar, who disagrees with Rabbi Akiva and says that the debtor is considered one who admits to part of a claim. This statement applies only in a case where there are no witnesses who support him. But here in the case of Rabbi Abba, where there are witnesses who support him, testifying that he repaid the entire debt, his legal status is certainly that of one who returns a lost item, and he does not need to take an oath that he repaid half, right? And we see there, normally, where is this idea of the oath? It's where it's just my word versus your word, right? Or, John's word versus Jerry, right? John says, I lent you $100. Jerry says, yeah, but I paid you back 50 of it. John says, you didn't pay me back any of it. Jerry says, I paid you back 50. So there's no witnesses. So in court, Jerry would have to swear an oath. That's something serious, right? We don't just swear oaths lightly because we're incurring ourselves the wrath of heaven, as it were. So if Jerry swears an oath that he paid back half, he's done. He doesn't have to pay back the other half. But that's in the absence of witnesses. If witnesses are there and testifying about part of it, then the oath is not the device, the legal device of bringing an oath into the trial would not apply. Okay, that's what I got today. Seeing a couple of questions. First from Joe. Were courts set up as ours are, where a certain court adjudicates issues within a certain area, or were multiple courts available within, say, a certain city? This is a great question, right? Because it brings up the question of forum shopping, right? Can you go, looking for a court that maybe will have, be friendlier to you or is more expert? Or was there just, the local court, that's the one you had to go to? I'm not sure. I think it certainly depends on how big your city is. There's probably going to be multiple rabbinic courts in a larger city. But do they have, is the jurisdiction done geographically, even within the city, regions of the city? Or is it more that the two parties have to submit to the authority of a rabbinic court? And then it's treated, sort of like the way these days arbitration is done. If the parties submit to the authority of those judges, okay, they submit it, so now they have to accept the ruling. Well, what if one party doesn't submit? Does the court have the power to, the police power to pull a person into court? I think in most cases, no. But the court would have the power. It's because they like sending someone to jail wasn't really one of the legal measures that was available. However, the court did have the power of ostracism, right? Particularly if we're talking about in the diaspora where there's a Jewish community. Okay, so, there's courts in whatever country you live, which are the legal courts of the land. The Jews would prefer to keep, their disputes within the Jewish community. So take it to a Beis Din, take it to a rabbinic court within the Jewish community. So if one party agrees to that, the other party doesn't. But the party that, brings the case before the judges has a very strong, reason, there's a lot going on here. Like in the case of an aguna, a stranded wife, it's a really big deal. She's not going to be able to remarry. This husband is being a jerk, but he won't submit to the authority of the court. Well, what the court can do is ostracize that man because he won't come to court, because he won't submit to the local rabbinic authority. And then, if nobody in town will do business with that man, it can become quite a problem for that man. Beyond that, other rules of jurisdiction, it's above my pay grade. I don't know. Bill, is it permissible to give one's heirs non-binding instructions in one's will? I'm thinking particularly of a man trying to leave something for his wife. Can he, for example, include a statement in his will that says, to my sons, I can't make you do this, but please give my wife X amount of whatever my estate is. I'd consider it a personal favor or something to that tune. For sure he can do that. I mean, that's really along the lines of an ethical will. Now, the sons are going to have an obligation to sustain the mother. I guess what you could be saying is, well, maybe they have a minimum legal obligation. The father wants more than that. But he can always make sure to take care of the wife by, using the language of gift and saying that this much property is set aside for my wife. I have that much now. Even if I acquire more property later, I have this value of property now, and on my death, this goes to her. It's hers as of now, but it only passed to her when I die. So he can definitely, use a legal instrument, put it in a will. He just has to word it properly so that it's not contradicting the laws of the Torah in terms of inheritance. That's why he has to go to the language of gift, even though he's placing it in the will and for legal disposition at the time of his death. But in terms of what you're saying, ethical will for sure. And we should all make sure to write an ethical will, which is not just, these are the values that I hold sacred and I hope that, you'll learn something from them, but also, these are things I would like you to do that affect, people, members of the family, etc. David left some instructions like that for Solomon about, people that he couldn't deal with in his lifetime, but that Solomon should take care of, and Solomon did. That's what I've got for us tonight. And with God's help, we'll be together again tomorrow, Sunday, at the regular time, 6 p.m. Pacific. Have a great night. Good Vach, Shavua Tov. Have a great week.